did share drinks together, and we talked and we laughed. Good to see you, sir.
You too.
You know, so much news was made in that interview.
Indeed.
And you saw the coverage. Let's start there. Your reaction. What does it say? What does it say to the American consumer about the news industry in general in this country?
Well, I think when you take a look at the White House Correspondents' Dinner and the conduct of the people there, and when you look at the absence of coverage of something so major as your show last night, it's pretty clear, Sean, that you're right. American journalism is dead. It's dying. It's in a coffin. And the fact is, these people are not journalists anymore. They're people with an agenda. They want to prove something. They don't want to find something out. They want to say something on their own. And this is an example of it. It's really a sad day, a sad, sad day.
Joe, we've had massive surveillance abuse,
Yes.
unmasking abuse. We've had the leaking of raw intelligence, Samantha Power unmasking a person a day. And then we have the bigger scandal. Rudy Giuliani is right. Supposed to be Trump-Russia collusion. It turns out Hillary is paying a foreign national to use Russian sources that turn out to be debunked. And then that false political document, that dossier, is used for a FISA warrant to spy on an American associated with the Trump campaign in the lead up to an election. They're virtually silent on the biggest abuse of power scandal in the history of the country.
Well, I don't think there's any doubt that judgment you've just made is absolutely correct. It is quite evident now that the Mueller probe is illegitimate. This effort to attempt to interview the president of the United States has now reached the point. They know that the president, under Department of Justice rules, cannot be indicted. They have no evidence to indict him. The office of Robert Mueller was created by Rod Rosenstein illegally. There, he mentioned no crime to be investigated. All of this leads to the ultimate conclusion that the perpetuation of this investigation by Mueller, it's doing grave damage to United States foreign policy. It's doing grave damage to U.S. law enforcement because of the thug-like tactics that have been used in the Manafort case and in the Cohen case. And it points to something that really is disturbing. After watching the Deputy Attorney General of the United States, Rod Rosenstein, accuse Congress of trying to extort him and others in the department by conducting legitimate constitutional oversight, I would say that between Mueller and Rosenstein and the absent Attorney General, God bless him, we have a very serious crisis in American federal law enforcement.
Oh, I agree. And I think it's the biggest abuse of power, corruption scandal in our history. Let's stay on Rod Rosenstein a second. Rod Rosenstein wrote a letter, said the FBI could never recover if James Comey stayed at the helm. So he would be a witness on that part of it.
Correct.
We've also discovered that Rod Rosenstein, we talk about the FISA applications that relied on unverified, uncorroborated, a dossier paid for by Hillary Clinton. They never told the judge it was paid for by Hillary. And then he went on to say that if there are false information presented to a FISA court, there's serious consequences. Isn't he implicating himself, the same statement when he said that he's not going to be extorted?
Of course. The problem here for Rod Rosenstein is he has multiple conflicts of interest. He shouldn't be supervising this case. He wrote the memorandum that led to the firing of James Comey. He signed the FISA applications. He continues to know and personally care about Comey and Mueller and others. He should be removed from this case. This is absolutely disgraceful. And now he will pretend that he is above all of this. But when all is said and done, Mr. Rosenstein represents a part of the department that I thought we had lost a long time ago when the Obama administration people left office, but apparently they haven't left office.
Joe, we're headed for a showdown, and that is every attorney that I know says the president should never sit with Robert Mueller, Andrew Weissman, his pit bull with his atrocious track record, his team of Democratic donors only, and if the showdown goes down, the president says no. If they won't agree to a proper written answers to legitimate questions, which I don't think they will at this point, then that means that it's likely that Robert Mueller will then subpoena the president of the United States before a grand jury. This is where it gets somewhat legally a little bit tricky. Let's walk down that road. What happens when, and what should the response be?
Well, first of all, I think that if Mueller issued a subpoena to the president, it would be an unconstitutional subpoena. Since he knows the president cannot be indicted, and since he knows that the president is not a necessary witness to anything that he is investigating, it is clear that he would be using the grand jury subpoena for only one reason: to get testimony from the president to use in an impeachment recommendation report to the Deputy Attorney General. That is an illegal use of a grand jury subpoena. The president should resist it. They should take it all the way to the Supreme Court, because under Article 2 of the Constitution, all executive power rests in the President of the United States. He had ultimate authority to fire James Comey. Be wrong.
We know that.
But it's going to go all the way to the Supreme Court if he issues a subpoena. Let me make a prediction. Mueller will never issue a subpoena.
Why?
Because he cannot win. I disagree with some of the comments of Judge Napolitano earlier about the fact that Mueller will win ultimately on a subpoena. Let me just say this. Mueller will lose ultimately on a subpoena because it is unconstitutional.
If it was
illegal.
granted and the president pled the fifth, then they would offer him immunity, and then the perjury trap remains. Correct or not?
That is technically correct, but you cannot issue immunity to someone when you are doing it illegally under the statute, because the only reason he would be giving him immunity would be to force testimony for an impeachment report. Mueller does not have the authority to issue an impeachment report, and he does not have the authority to use a grand jury subpoena to get presidential testimony for impeachment or any other criminal activity that never occurred, because he's dealing with the power of the president to fire people. So if Mueller wants to have that fight and tie it up in the courts for 6 months to a year, he can do it. But he will be doing a grave disservice to himself, because at this point, Mueller has become a cross between Madame Defarge and Inspector Javert, and it's an embarrassment.
All right, Joe DiGenova, always appreciate you being on the program.
A sitting president's amenability to indictment and criminal prosecution. The indictment or criminal prosecution of a sitting president would unconstitutionally undermine the capacity of the executive branch to perform its constitutionally assigned functions. Page after page after page saying a sitting United States president cannot be indicted. Now, my question is this. Did they issue another memo over there at the Justice Department reversing these two memos during the Nixon administration and the Clinton administration? No.
He joins us himself with reaction. The host of CRTV's Levin TV, the host of Life, Liberty, and Levin, the #1 show, Sunday nights, 10 Eastern, right here on the Fox News Channel. I call him the Great One. Mark Levin, I wanted to play that again because, as usual, on legal matters, you're ahead of the curve. You are a constitutional attorney, and our lazy, overpaid liberal activists that call themselves journalists are wrong like 99% of the time. So I want to go through this legally tonight and give you the opportunity to explain it to them yet again.
All right, Sean. This is not me speaking. This is the Department of Justice speaking. And the position of the Justice Department has not been repealed and has not been amended since the last decision on October 16, 2000. The President of the United States, this is getting way too complicated and unnecessarily so. You've got a lot of second-tier slip and fall lawyers all over TV spewing things they don't know. They don't understand the Constitution. They haven't studied the cases. I have. First of all, this opinion says, among other things, that grand juries and prosecutors cannot supplant Congress. They cannot supplant Congress. The only way to remove a sitting president is through the impeachment process, not through the indictment process. They cannot disable or hamstring a presidency, which is what they're trying to do as I speak. A prosecutor cannot trigger the 25th Amendment. The 25th Amendment the purpose is not to be triggered by a prosecutor, and he can't step in and try and take advantage of it. These are things that were discussed. The president cannot properly defend himself in litigation under the Constitution as an individual American when he has time that he has to spend on official duties. Unlike so many other individuals, a president of the United States, they point out, is so unique in our constitutional system that it is enormously damaging to him because he can't focus on his defense, which is different than civil litigation, and he can't focus during that time on the nation's security and well-being. And the presidency can't function properly with these kinds of burdens. This is what the memo says. He cannot be indicted. All the pablum about, well, presidents have received subpoenas before. Tell me, name one president who's ever been before a federal grand jury. There's never been a president in front of a federal grand jury. Ken Starr's team subpoenaed Bill Clinton for having, among other things, not sex so much with an intern in the Oval Office, but lying about litigation that was taking place. And he was subpoenaed, and he decided to do a video. So here's my advice to the President of the United States, who didn't seek it, and to his lawyers. Focus. You're making this too complicated. The Constitution is on the side of the President. The Department of Justice's own position, which you can brief yourselves, is on the side of the President of the United States. Historical precedent is on the side of the President of the United States. Legal precedent is on the side of the President of the United States. Stop listening to all the babbling, pleading the fifth, and should he sit down with a subpoena? I would say, if I were the president's lawyer to Mr. Mueller, we want you to present us with an explanation of your defiance of the Department of Justice policy, which you are required to follow as an employee of the Department of Justice. Moreover, we want to understand how it is that you believe that you can burden a president like this while he's in office. And while I'm at it, Sean, we seem to have a few Republicans in the Senate who are very confused about these things, who have voted to protect Mr. Mueller rather than protect the office of the presidency, the Constitution, and the American people. And they seem to think that they have the power, even though we have separation of powers, to tell a president who he can hire and who he can fire. The part of the problem the president has is he's dealing with ignoramuses, both inside his party and outside his party, and some of whom are dressed up as lawyers. So I would take this all the way to the United States Supreme Court. I would make Mueller and his band of Democrat prosecutors make their case all the way to the United States Supreme Court. If they try to subpoena him in any way to appear before a federal grand jury, and make them make their case against their own Department of Justice, against Supreme Court precedent, and against the Constitution of the United States. And if it takes 6 months, it takes 6 months. And if it takes 6 years, then by God, it takes 6 years. We're not just talking about the president, which would be enough. We're talking about protecting the office of the presidency, separation of powers. And when you look at those 49 areas of questions, there's not a single criminal statute. There's not a single obstruction. What has been obstructed? They're not investigating Russia? What is it that they're not investigating that they don't want to investigate? No. They want to know his intent on whether he obstructed. They want to treat him like they treated Martha Stewart. Well, guess what? He's the president, Mr. Mueller. This isn't President of the United States. You know what that means? We, the people, have a stake in this. We, the people, get to decide. The framers decided the only way you remove a president is through the body politic, through the House and the Senate, and it's a heavy burden, not by some rogue prosecutor with a bunch of Democrat prosecutors. They don't get to do it, and the people need to rise up and demand that this go all the way to the Supreme Court to put these rogue prosecutors in their place.